Hey everybody, Todd Vanderbind, former NRA contract lobbyist, Illinois gun law guru, the gun Santa, and here we are on July 2nd. The Supreme Court has turned away the cert petitions for all the Illinois gun bans. So let's get into it. Hey everyone, back for another edition of Freedom Steel. Thank you very much. It's mid-afternoon on the 2nd of July, so two things. One, uh, let's get into it and start the 4th of July weekend just a shade bit early as it is 5 o'clock somewhere. So today, this morning, the Supreme Court in their cleanup orders listing of the closeout of this term of the court, it had an orders. Now, it wasn't on the calendar, but typically, as I predicted, the court normally issues a set of cleanup orders with remaining cases that have been hanging out there once they have concluded the session. They concluded the session yesterday with the talk about presidential immunity, a couple other cases, and so today they turned around and issued orders. And in the orders, the grant for certiorari and the Illinois gun ban cases were denied. They were denied with Justice Alito saying he would have granted cert. That's important for a reason. And Justice Thomas giving a statement. Justice Thomas did not dissent from the grant of cert, and that's a different issue, so let's get into it. First off, this term with the addition of Amy Coney Barrett and a couple of the other justices, the judges are slowing down on the shadow docket from what I can see, where it's that just emergency docket, which has been nicknamed the shadow docket. And they're slowing down on that. And they are slowing down on grants of cert on interlocutory appeals. That'll get mentioned here in Justice Thomas's comments. Interlocutory appeals, the easiest way to describe it for a layman is they're in an administrative state. They are not a final judgment saying you won, you lost, this is what the law is. No, what this is we had gained a injunction against the implementation of the law, and the state appealed that up, and the Seventh Circuit said, no, we don't think you're going to win on the merits. Therefore, we are going to put a stay on and shut down the injunction. And we appealed that up. And this was, so we are still in an administrative state because we don't have a final determination on the merits. So, what do we got? I think Justice Thomas's comments shed a lot of light. I also think that the pending trial for September on our case hurt us as well. Remember, late last year when all the Second Circuit BS was going on, the court admonished the Second Circuit and said, hey, you got to take this stuff up expeditiously or give real reasons. You just can't be issuing summary stays against injunctions. And if you'll also remember that earlier this term, the court was knocking down a bunch of injunctions coming out of the Fifth Circuit. And they started to use that as an applicability that remedies that, hey, not everything deserves an injunction. We need to be judicious in this. We need to be stingy in doling these kind of things out, which leads to a bunch of frustration on our side. When the abortion guys had a majority on the court, and there was an anti-abortion law that was passed. There was an injunction passed up sometimes nationwide by judges depending on the issue, and those were never overturned. Those were never struck down. And so it always seems like the Second Amendment is still a disfavored right, a second class right that goes on to deal with this. But I think these are fundamental administrative changes that are taking place within the court that you are seeing take place right now. And conservatives are going to be true to their cause no matter what. And even if it hurts some of the issues on their side of the playing field, they want to try to be consistent. Now, with that, let's talk about. So it says Justice Alito would grant petitions for writs of certiorari. So it has been reported by me and others. So I heard several people back in the days say that Justice Scalia in private had said that there would not be 4 votes for cert if there were not 5 votes to win the case. And recently I heard Alan Gottlieb say the same thing that Justice Alito had told him. So confirmation from Alan Gottlieb that he had a direct conversation with Justice Alito, and this was said. Justice Alito would have granted cert. That tells me that Justice Alito believes there are 5 votes to overturn these gun bans. They are simply waiting for things. Now, they had Bianchi in front of them, but Bianchi had been argued in front of an en banc panel and was waiting. So it's in this administrative state. They wanted a cert before judgment. And I think the court, if you go back to the Idaho abortion case that they turned away last week, they turned it away for, dismissed for being improperly granted. They called it dig. I think that is another one where they came in interlocutory and the facts changed, something changed in the case. Here they are. They don't want to, and now they're dismissing it because it's all different. They don't want that. They want a clean set of facts. They want a record. They want to deal with a final issue. The Loper Bright Chevron case, that, I think that was a final issue one way or the other. I just don't see them jumping on here for a lot of stuff. So let's read what Justice Thomas wrote. The state of Illinois enacted a law that makes it a felony to possess what Illinois branded assault weapons, a term defined to include AR-15s. And I'm going to cut out all the sites and gobbledygook in here. The AR-15 is the most popular semi-automatic rifle in America, and there is therefore undeniably in common use today. Petitioners sought a preliminary injunction against the enforcement of the law, arguing that the law violates the Second Amendment right to keep and bear arms. The Court of Appeals for the Seventh Circuit rejected petitioners' request for a preliminary injunction, concluding that the AR-15 is not protected by the Second Amendment. According to the Seventh Circuit, the rifle selected by millions of Americans for self-defense and other lawful purposes does not even fall within the scope of the arms referred by the Second Amendment. This court is rightly wary of taking cases in an interlocutory posture, but I hope we will consider the important issues presented by these petitions after the cases have reached final judgment. There you go. The interlocutory nature of our case doomed the appeals for cert. But he's making references to Heller and talking positively about AR-15s. We've never squarely addressed what type of weapons are arms protected under the Second Amendment. To be sure, we explained in the District of Columbia that the Second Amendment's protection extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Remember, they cited that passage in Rahimi, and Rahimi was about prohibited persons. And we noted that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, recognized in the historical tradition of prohibiting the carrying of dangerous and unusual weapons. Notice the dangerous and unusual. And he cites Catano. But this minimal guidance is far from a comprehensive framework for evaluating restrictions on types of weapons, and it leaves open essential questions such as what makes a weapon bearable dangerous, or unusual. The Seventh Circuit decision illustrates why the court must provide more guidance on which weapons the Second Amendment covers. By contorting what little guidance our precedent provided, the Seventh Circuit concluded that the Second Amendment does not protect, quote, militaristic weapons. It then tautologically defined militaristic weapons as those that may be reserved for military use. The Seventh Circuit's contrived non-militaristic limitation on the arms protected by the Second Amendment seems unmoored from both text and history. And even on its own terms, the Seventh Circuit's application of its definition is nonsensical. The AR-15 is a civilian, not military weapon. No army in the world uses a service rifle that is only semi-automatic. In my view, Illinois' ban is highly suspect because it broadly prohibits common semi-automatic firearms used for lawful purposes, citing his dissent in Freedman. It is difficult to see how the Seventh Circuit could have concluded that the most widely owned semi-automatic rifles are not arms protected by the Second Amendment. These petitions arise from a preliminary injunction, and the Seventh Circuit stressed that its merits analysis was merely a preliminary look at the subject. Remember, they said they might be persuaded to change their mind. But if the Seventh Circuit ultimately allows Illinois to ban America's most common civilian rifle, we can and should review that decision once the cases reach a final judgment. The court must not permit the Seventh Circuit to relegate the Second Amendment to a second-class right. So, there you have it. The down and dirty of this is the pending trial, the interlocutory nature, and the Seventh Circuit's dicta that they could be persuaded to change their mind if there was a bunch of evidence at trial. And I think that goes into what they've done in a couple other cases, and they did a whole bunch of GVRs today, that they want the lower courts to dive in and really do a lot of work. They want them to do the heavy lifting and to do what judges are supposed to do: weigh the facts, look at the evidence, make determinations. And I think that is what has, hurt our chances. But what Justice Thomas is saying here, and Justice Alito would have granted cert, and with the chief saying, hey, in Rahimi, the Second Amendment protects all, modern firearms, I think that we are on the path. It is just going to take some time. It's annoying. It's frustrating. It's maddening. It's disheartening at times. But I think we are on the right path with this court. The trick is how to get a case up there next term pronto. So we'll see now what happens with Bianchi, what happens with Duncan, what happens with Miller, what happens with a bunch of other cases. We shall see. And that's a whole discussion for another video, as I'm running up against the 15-minute clock, which I try to keep these under. We will go into where we are, what that all looks like. And you have Viramontes from Illinois pending out there as well. So with all that, please like, subscribe, copy and paste the link, share it around your social media areas, pages. Let everybody know. We really appreciate all the support we're getting here. And I've got a ton of stuff I'm going to try to knock out today in front of the weekend to give you guys a bunch of stuff to look at. So with that, frag out.